Good morning, everyone. Welcome to this breakfast briefing, myself and Hugh Flanagan. And we're going to be talking about two challenges this morning, unsuccessful challenges, I'm pleased to say, to a grant of development consent for our clients in the East Anglia 1 North and East Anglia 2 wind farm cases. And we're able to talk about it now because the unsuccessful claimants in both cases were not able to persuade the Supreme Court to grant them permission to appeal. So it's now the end of the road in terms of the challenges to these two development consent orders. So we're going to run through the agenda, starting with the Suffolk Energy Action Solutions case, which I'll deal with, and then Hugh will deal with the Substation action case, and there'll be an opportunity for questions at the end. For those watching online, there's a question facility. If you post your questions, and then they'll be fed through to us, and we'll try and deal with as many as we can at the end of the presentation. So I will start, because we've got quite a bit to get through, so I'll just crack on with some introductory points about the Suffolk Energy Action Solutions case. And it's important when you're looking at this case and trying to understand its implications to look at both the High Court and the Court of Appeal judgments. You can't simply go to the Court of Appeal judgment. I think you need to look at both to understand it. The claimant's case changed significantly between the High Court and the Court of Appeal, and the issues that are covered in the judgments are related, but they're not the same. And so it's important to understand that. It's also important to fully understand the factual context. And as is his practice, Mr. Justice Holgate dealt very clearly and extensively with the facts at first instance, not least because that was the focus of the claimant's case at that stage. So there's a huge amount of effort put into examining the facts by both sides. And so you'll get a much more detailed and nuanced understanding of the facts and how they then influence the Court of Appeal's judgment, because the Court of Appeal is able to draw on those, and to understand the implications of the way that the Court of Appeal decided it. There are also, as I'll come to, some useful practical and tactical points to be gleaned from the High Court judgment, which you might miss if you just go straight to the Court of Appeal. So a brief overview of the facts. The claimant was a group called Suffolk Energy Action Solutions. They were an unincorporated local residents group. They incorporated themselves for the purposes of judicial review, a fact which became significant in the High Court litigation in terms of the timing and how that related to what they were doing at the time. Their position through the examination was that they said, well, we support renewable energy, but as ever, not this one. And in particular, they weren't concerned about the offshore works, but they didn't like the onshore works, and in particular, the new substations. The development that was consented was 2 offshore wind farm NSIPs. So you've got 2 DCOs for 2 closely related offshore wind farms. But you also had, of course, all the cabling that brought the energy on shore, and you had a new substation outside the village of Friston in Suffolk and a new national grid substation next door to it. And those were the things that were the focus of particular objection. The DCO included powers to compulsorily acquire the land that was needed for the onshore works, which lies at the heart of this particular challenge. And of course, these were NSIPs. And so both went through the Planning Act 2008 system and the inquisitorial process. Another factor which is important to keep in mind when you're looking at the judgment of the Court of Appeal and its implications. They were both EIA development, and so the EIA regulations applied. Again, an important factor in the ultimate outcome. Those are all things which need to be kept in mind when you look at the issues that arise from the judicial review, because they all have implications in terms of how this case will apply in other situations. The next heading, SSESNZ complaint. This was, I put it in this way because it was originally raised as a complaint to the examining authority, and the complaint arose from the efforts that our clients had made during the examination and beforehand to acquire the land they needed by negotiation under the shadow of threatened compulsory acquisition, and something which, of course, as you'll know, is in line with government guidance. And the essential nature of the complaint was summarised by Mr. Justice Holgate at paragraph 19 of his judgment as follows. The claim arises out of a complaint which SSESNZ made to the panel in a letter dated 14th of January 2021. The claimant said the integrity of the planning process was being undermined by the inclusion of a clause in the interested parties' agreements with landowners which required them not to oppose the application for the DCOs and to withdraw any representations already made. It was also said the clause had prevented landowners from talking to associations such as SSESNZ, which opposed the application. The agreements were said to have had a chilling effect. It was also contended that the applicants had improperly offered substantial payments to induce landowners to enter into agreements which prevented them from supplying information and evidence to the examination. The promoter had used the prospect of obtaining powers of compulsory purchase as a lever to secure the withdrawal of opposition to the project. So that, in a nutshell, was the complaint they made. And it arose out of two types of agreement. First, and probably most importantly, heads of terms. So these were a set of non-binding provisions which indicated the, as the name suggests, the terms that would be included in a future contractually binding option agreement. Under the heads of terms, there was no payment to be made in respect of signing up to the heads of terms until the option agreement had been entered into. So save where there was some initial interference with land which needed to be compensated, essentially all payment was deferred. So no one had actually received any money. These were non-binding agreements. But they it included, as the judge's summary indicated, a provision dealing with non-objection. And the term in question, in what I anticipate fairly standard terms, the grantor will not object to the developer's application for development consent, nor any other planning applications associated with the project. So that was the non-objection clause. And there was also a confidentiality clause, which had an exception for informing the examining authority of the existence of the heads of terms, the fact they've been entered into, but essentially was designed to ensure that the terms that had been agreed, in particular about compensation, were not widely promulgated, all relatively straightforward and unexceptional in most cases, certainly something which has been well precedented in many other cases. There were also option agreements, but none had been signed up to by the close of the examination. And there were only two signed up to before the decision, and those only a matter of days before the decision. So they had no influence on the gathering of evidence or the consideration of objections. They also included a more elaborated version of the non-objection clause, which included the point about withdrawing objections, and a similar clause in terms of confidentiality. Now, the grounds on which the challenge in the High Court proceeded were rather diffuse as pleaded, and they evolved during the course of the litigation and were ultimately refined through a process of Mr. Justice Holgate interrogating David Wolfe at the start of the hearing and narrowing it down to the four grounds that are set out in the judgment, paragraph 35. Now, I don't propose to go through those in detail, primarily because none of them succeeded, and the more significant issue lies in the one that ultimately was picked up and run in the Court of Appeal. But in short, they're a combination of an allegation of a failure to consider the effect of these agreements, to investigate them, to have a full EIA on the basis that information might have come out, which didn't come out, and also to give adequate reasons for rejecting the complaint. It's a sort of fairly standard package of public law concerns. But the key point to understand in terms of the way the case was run at first instance is that there was no complaint made about the lawfulness of the agreements themselves. So paragraph 31, the judge recorded this. Mr. Wolf stated that the claimant does not argue that the heads of terms or the option agreements were unlawful or contrary to public policy. I agree. For many years, agreements with landowners to dispose of their interests voluntarily, where powers of compulsory purchase are sought, have provided for the agreed terms to be confidential and for the landowner not to oppose the scheme. Mr. Wolf accepted that the subsequent introduction of legislation on EIA and assessment of impacts on European protected sites and species had not rendered such agreements unlawful. And that is a point that the judge repeatedly came back to in the judgment and tied it in paragraph 87 to the previous decision of the Court of Appeal in Fulham Football Club Limited versus Cabra Estates, which we dug out early on in the litigation, in which there had been similar clauses in an agreement between the two parties to that litigation, commercial parties, and the Court of Appeal had held that that was not unlawful because of being contrary to public policy. And so the judge said that the claimant's position here was not surprising in view of that case. So that's the factual context for what then followed. So the key points from the first instance judgment I've broken down into under two headings. First is some context for the central issue of law that the case gives rise to, and then there's some other useful points which I just want to touch on. The first is the inquisitorial process. Now, the judge set out at the paragraphs that I've indicated there, 43 to 51, a whole series of features of the examination process under the Act, which reflect but also give effect to its inquisitorial nature. So he starts off by recognizing that the examination process is inquisitorial, not adversarial, by reference to the Haylight decision, and then runs through the provisions that apply both under the Act and under the regulations that have been made pursuant to it, which give the examining authority very considerable powers to make its inquisitorial process effective. And the point that we made from the outset was, well, that's important because this is not a process that depends on people objecting to get to the truth. Effectively, the panel can get to the truth even if no one turns up because it has very considerable powers. Also important that the heads of terms were not binding. Now, our clients during the examination had made clear repeatedly, these heads of terms are not legally binding. In other words, you're not bound by anything that's in them. The confidentiality, as the judge recognized, might be something that would be able to be enforced outside the concept of the heads of terms contractually, but they weren't binding. And the claimant sought to argue both in the examination in the High Court that they were, but got nowhere, unsurprisingly, on that. But importantly, by making clear publicly, repeatedly during the examination that they weren't binding, anyone who had signed up to those heads of terms would or should have known that they were not prevented from objecting if they wanted to. That wouldn't put them in breach of their agreement. Similarly, the point about the chilling effect, it's all very well as a slogan or a headline, but you have to have some evidence that there's been a chilling effect, and the facts just didn't support it. And I've identified in the notes two important paragraphs that deal with the way that issue arose. Now, the examining authority's response is important and I think raises wider questions. This is reported in the judgment of paragraphs 96 through to 98 with a comment on their response from the judge at 99. And essentially what they did is once the complaint had been raised, the examining authority made a procedural decision. that was partly about setting up a process for examining the issue and allowing the parties to make their points to them. But the examining authority went further and made some initial comments, and those are reported at 98, and they said, so far as is relevant here, the applicants, all interested parties and affected persons are reminded of the need to ensure that normal and necessary dialogue between applicants and affected persons conducted to narrow matters in dispute and reach concluded settlements where possible should not raise any reasonable apprehension in the minds of affected persons that they are to be prevented from enjoying their statutory rights of participation in these examinations, or that their related human rights are not being responded to. And then they went on to say, it is not in the public interest that there should be any enduring apprehension on the part of an affected person that they might be prevented from participating in these examinations to raise their outstanding planning merits objections. So going further than just setting up a procedure and appearing on the face of it to express views about the underlying subject matter. And as the judge went on to comment, paragraph 99, the panel said that SEAS had raised a, quote, general point of public interest, unquote, but they may have done so without a full understanding of or access to relevant information. In other words, they'd slightly jumped the gun because at that stage, of course, they hadn't had submissions about whether this was a point of public interest and whether any of these concerns were well-founded. But having taken that step, the claimants were encouraged, as you might expect, and they also relied on that subsequently in the litigation as suggesting, well, they had a point of public interest. Therefore, it ought to be considered, therefore, they ought to get permission, and so on and so forth. But the examining authority did not ultimately issue any decision during the course of the examination. They said they might do that, they might leave it to their report, and dealt with it only briefly in the examining authority's report, leaving the claimants claiming that, well, it hasn't really been properly looked at. The facts are also important, not just in terms of those which are unfavourable to trying to get home on this sort of claim in this particular case, and I've identified the relevant paragraphs there, but also the way that the case was run, both during the examination and afterwards. And you'll see in amongst the paragraphs that I've identified, if you go to look at them, that the judge was plainly not impressed with the way the claim had been pursued, and it gave the impression that this had been more opportunistic, trying to set up a challenge than principled, and I don't think that ultimately helped in terms of gaining judicial sympathy. Other useful points, well, there are 3 points I've picked up here which are useful, I think, for practitioners. The first is consideration of full information, a concept in EIA terms, which has its origins in what Lord Houghton said in the Brown case as being the purpose of the legislation to secure full information for the decision maker, caveated to some extent by Mr. Justice Sullivan, as he then was, but David Holgate took the opportunity to add his own little point at the end. He said, I would merely add that the word full has a wide range of meanings, depending upon the context in which it is used. Full is used in the sense of sufficient to meet the requirements of the legislation, and not, for example, full to capacity or exhaustive, which when you're asking yourself whether you've got enough environmental information is quite helpful, particularly if you're facing complaints by environmental litigants, you haven't provided full information. And that was endorsed by the Court of Appeal at paragraph 23. So I think they're quite a useful point for practice. Second point, links to post-examination representations in the DL. There was an interesting little point of law that arose. In the decision letter, links had been provided to the post-examination representations about this issue by the complainants and the interested party. And the text of the decision letter said the Secretary of State has given further consideration to these points. And the claimants argue, well, that doesn't mean that the court can assume that the Secretary of State has actually read those representations. And the court said, no, we think that is enough. That's enough. And so when you're in the post-examination stage, and there's often a concern that you might have a challenge that doesn't fully summarize or the cases or the issues, by providing detailed submissions that can be used in the decision letter, linked to the decision letter and framed in this way, you effectively incorporate that information into what was before the decision maker. Because a common line of challenge in these cases is, well, the decision maker didn't look at what we said about X. It's all very well saying that the civil servants looked at it, but all the decision maker had was what's in the draft decision letter. This is a useful way of incorporating more and being able to say the secretary actually read it. And then the final point, CPR Part 18, this is something which we used as interested parties to attack the rather loose pleadings of the claimant, seeking effectively further and better particulars. And although the responses we got were characteristically useless and evasive, the judge picked up on that, and it was effective in the hearing. And you'll see that in the references I've given that the judge thought that that was significant, their failure to provide proper answers to those questions. And I think it's a procedural step that is not often used and is not used enough. And it can be highly effective, particularly where you've got claimants who are seeking to keep their options open and to give themselves plenty of scope to evolve their case as it goes on. So now on to the Court of Appeal's judgment. The appellant changed tack significantly for the purposes of Court of Appeal. So whereas it had been made very clear and emphasised by the judge they hadn't attacked the lawfulness of the agreements in the Court of Appeal, that was the focus. Focus was actually these are unlawful as contrary to public policy. And so paragraph 9 of the Court of Appeal's judgment records the contention that these provisions were unlawful because they precluded, or if they were not legally binding, had a tendency to dissuade the landowners from raising any objections to the proposed development, even those wholly unrelated to the impact on their own land. So effectively, they were saying this is an unlawful agreement. And therefore, the failure to deal with an unlawful agreement made the decision itself unlawful. We therefore had quite a lot of focus on the Fulham versus Cabra Estates case, submissions as to whether or not that case was distinguishable. And then the appellant put forward an alternative argument, which is, well, if these are lawful, they're only lawful if the non-objection is confined to development on the land to be acquired. The Court of Appeal rejected the appellant's case, as now formulated, two main reasons. First of all, well, if the applicant owned all of the site, the applicant is unlikely to object to its own scheme, and that isn't a problem in the process. It doesn't undermine the integrity of the process. So if the process works, if the applicant already owns the land, why is there a problem if some of the owners of the land agree, because they consider it in their own interests, to sign away their objection for some benefit? What's wrong with that? The process works, whoever owns the land, it's designed to do that. So it's unlikely to be a problem. That was a point that we thought was important right at the beginning of the process, and ultimately it found its way into the core of the Court of Appeal's reasoning. The second, and this comes back to why you need to be careful about applying this more widely, the planning process is inquisitorial in nature. And it's for the decision maker to ensure there's sufficient information, and whether the effect of a non-objection clause has meant there is insufficient information must always be a fact-specific inquiry. I'll come back to that in a moment. So the alternative argument that it's only lawful if it relates to development on the landowner's specific piece of land is that, well, there's only one scheme. and the developer is entitled to require the landowner not to object to the application, even if the application goes beyond the land in question, which as a matter of practicality makes a lot of sense, because you've got a big scheme and you've got multiple landowners, I think in this case about 55. It doesn't make much sense if they can't object to the little bit of cabling on their land, but they can object to the substations, for example. Then essentially relied on the two key reasons I've been through, and then for those reasons didn't need to determine exactly what the RICS guidance meant, which was the sort of prompt for the claimant's case. Landowners may be prevented from objecting to any planning applications in relation to their land. And so the court didn't think it needed to get into that. But reasons to be cautious. The reasoning you'll have seen in relation to the inquisitorial process is specific to the Planning Act 2008, and that is reflected not just in that which Mr. Justice Holgate said, but also in relation to what the Court of Appeal said. And I've identified the relevant paragraphs in the judgment that make that clear. Reliance was also placed on the operation of the EIA regulations, which of course oblige the decision maker to ensure they've got adequate information and don't rely on the landowner, and that won't apply in all cases. And even then, the effect of those factors meant that in general, such clauses would not prevent the decision maker making a properly informed decision. And then, crucially, of course, whether this is so in an individual case will always depend on the particular facts. The particular facts here that were relied on by the Court of Appeal, heads of terms weren't binding. That won't always be the case. But commonly be the case that landowners will sign up and enter into binding option agreements before you get to the end of the examination. The landowners had legal advice. Quite useful sort of factual matrix here that the landowners' solicitors have been involved in drawing up the generic heads of terms. They'd all had advice. And indeed, one of the principal complainants was particularly well advised because he had a family member who was an experienced surveyor who'd been advising him as well. The applicant had made clear heads of terms were binding. So as I said, it was made repeatedly clear in open hearings, in representations to the examination. So things that would have been available to all the landowners, you are not prevented from objecting. No option agreements until just before the decision, and then only 2. 39 of the 55 landowners who'd signed the heads of terms objected, and none of them withdrew. Also very helpful facts. And then the Court of Appeal said, in these circumstances, there was, in our view, no conduct interfering with the administration of justice. So before I hand over to Hugh, as you'll gather from that, I think one needs to be just a little bit cautious in applying this more widely and considering whether in individual cases you've taken sufficient steps to minimize the risk that this sort of claim might arise on your particular facts. Okay, well, I'll now hand over to Hugh.
Thanks very much, Harry, and good morning, everybody, online and in the room. So I'm going to talk about the second of the 2 cases on the agenda this morning, the substation action case. So these are the same DCOs being challenged, the EA1 North and EA2 DCOs, but a different claimant, entirely different organisation, and no overlap in the grounds at all. A sort of a salutary warning that when one claim form lands after you get your DCO, it may not be the end of the story at all, and there may be more coming. And they proceeded in parallel. CAS was slightly behind substation action, but they both went to the High Court of Appeal and both applied to the Supreme Court, both turned down. The substation action case on one level was a much more conventional challenge. You've got the grounds there on the slide, quite familiar grounds from many other DCO challenges, other planning challenges over the years. But interesting in the number and range of them, I think. There were six, two made it to the Court of Appeal, 6 in the High Court, and they really explore a lot of the risk areas that arise for many projects, and it makes the High Court judgment in particular read something like a textbook of, you know, how to bring and how to resist an infrastructure project legal challenge. You know, identifies the areas, looks at the relevant law, and provides some potential answers. Some of it's quite fact specific, for instance, the noise challenge, but others are much less fact specific and are obvious application, I think, to other schemes, obvious relevance to other promoters and decision makers to see how challenges might come forward, how best to avoid, anticipate them. I appreciate that'll be of little comfort to the team at Scottish Power, who spent 2 years fending off these challenges, but at least we have the benefit of them now. And as I say, I mean, the context was offshore wind here, but it seems to me a lot of them are equally applicable to the brave new world of onshore winds that we're back in, solar, other renewable schemes, particularly as Harry said, that the substation action, just like SEAS, was saying, we're very happy about the offshore arrays. Well, they can go ahead, that's fine. It's all the onshore stuff we don't like. That's the target of the attack. And so it's on land and of relevance to other projects on land as well. So starting with the first of the menu of topics, flood risk. I start with it. I mean, it was ground one in the High Court. It was one of the ones that made to the Court of Appeal. It was essentially the primary ground, I think. Most attention paid to it by the claimant in the court. And despite seeming a somewhat sort of technical area, flood risk, the preserve of flood risk engineers, not for us lawyers or planners, actually it has become something of a flashpoint recently and does require, I think, quite a lot of attention by anyone promoting or deciding on a scheme. Policy was tweaked in the framework and then in the national policy statements a couple of years ago, and tweaking policy always risks provoking challenge. And that materialised in this case. And particularly, flood risk is a particular area of attack, I think, because it's one of those areas where if an objector is successful, it doesn't just mean that the development should be modified or extra mitigation should be provided. It can be a showstopper, i.e. that the development should be not here but elsewhere entirely. And so it's if you really want to object to a development, it's potentially quite a fertile ground of attack, as opposed to, for instance, the noise grounds. It might involve further mitigation, but you still get the substation which you don't want in your back garden. And so it's the flood risk sequential test that was the focus of the challenge. And you have the policy on the slide there. Essentially, the policy is materially the same across the framework, the national policy statement, which applies to infrastructure, and the planning practice guidance. And the key sentence is the first one in bold at the top: the development should not be allocated or permitted if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding. And so, in terms of what's important in that policy, the first point, I think, is that the clarification, the tweak in the 2021 framework, is that it's been emphasised that it applies to all sources of flooding. So, in fairness, I think, to the policy drafters, I think that always probably had been the intention of policy, but previously there was a focus on fluvial rivers and tidal flooding, because they underlie the flood zone approach. But the 2021 framework and the 2023 NPSs make clear that it's all flood risk. So it's particularly relevant to surface water, groundwater, and other forms of reservoir flood risk. But surface water was of concern in the present case. And that is important because the flood zone concepts are relatively straightforward and easy to understand, because policy is quite prescriptive. It tells you if you're in flood zone 1, 2, 3, 3A or 3B, and then when you're in which one, policy tells you what to do. but that only applies for fluvial and tidal. For other sources of flooding, surface water, groundwater, you don't have that nice mechanistic policy framework which tells you what to do. It's much more judgment-based. That leaves room for challenge, people objecting, decision makers to do their own thing a bit more. So inevitably more risk and more attention needed potentially. And so in the present case, the brief facts were that there was surface water flood risk on the national grid substation site. So there were project substations for these offshore wind farms. And then there was also a national grid substation to which the project substations would connect into. And the national grid substation particularly, the focus was on surface water flood risk there. And the surface water flood risk was, in the applicant's view, eminently manageable. It was, as you see there on the slide, a shallow surface water flow route of 4 centimetres of depth in 1 in 100-year storm event. So not a raging torrent, and capable of being diverted around the side of the substation. And the applicant's view, no reason to start going to look for other sites when you've got a particularly perfectly good site here. And the point being made that essentially virtually every bit of land across the country has some surface water flood risk. So where do you stop? The objectors disagreed and they said, no, this is not immaterial, it's surface water flood risk, you should be looking elsewhere. You fail the sequential test, therefore refuse development consent. Secretary of State agreed with the applicant, said sequential test is passed, said in light of this surface water flood risk, in light of how it can be managed, no reason to think the policy is not complied with. And the important finding on this in the High Court and Court of Appeal, of importance, I think, to future projects as well, is that last text on the slide there, that the relevant provisions of EN1, the MPPF and the PPG do not require that wherever there is a risk of flooding from surface water, an application of development consent must demonstrate that there is no other reasonably available site with a lower risk of flooding. So making clear that just because you have some surface water flood risk, that does not automatically mean sequential test has failed. You need to go and start looking at other sites. There is judgment involved, and that judgment can include how you might manage and mitigate that risk. The objectors said, well, that conflates whether there's risk and how you manage it, and obviously involves some conflation of those two aspects, but it is Court of Appeal on the facts of this case found to be legitimate. And the other takeaway, I think, from that is that the Court of Appeal and the High Court are accepting that you can't simply read across from the flood zone approach, which is relevant for rivers and tidal flooding, to other sources of flood risk. So in the flood zone approach, if you're in flood zone 1, you're automatically okay. If you're in flood zone 2, you automatically need to be looking for other lower risk sites. That, as I say, a mechanistic approach just does not apply to other sources of flooding. So that's the sequential test. More briefly, it wasn't really an issue in the litigation, but the other aspect of flood risk policy is the exception test. You only get to this if you pass the sequential test and there's flood risk. So for instance, for fluvial flooding, if you were in flood zone 2, so there's some flood risk, you've looked around, can't find any zone 1 sites, you then have to pass the exception test. And that involves showing that, firstly, you've got wider sustainability benefits from your scheme. And I mention that because those expressly include renewable energy in policy. I think it's a footnote in the MPS, and often overlooked. I think that the drafters of the MPS are deliberately saying that these schemes may need to come forward in higher risk flood zone areas, and we know that because they've created an exception in the policy for that. And the other aspect is that the development has to be safe for its lifetime. And then there's another sort of carve out, essentially, small carve out for energy related development because wind turbines, solar farms, electricity generation are classed as essential infrastructure. That doesn't mean that flood risk policy doesn't apply, but it means that you can have such development in flood zone 3. So again, an acknowledgement that there may need to be some such development in high flood risk areas for the purpose of the exception test. So that's the exception test. Just turning to a few other areas of interest on this. So going back to the sequential test, there are essentially 2 stages that need to be gone through when applying it, which has become clear, I think, both from the SSESNZ litigation and another case, which is going through the courts at the moment, which I'll just touch on. So the first is to define your search area. Obviously, if you're looking for alternative sites with lower flood risks, it's crucial to know which area you're looking at, and drawing a red line around the relevant area and then looking for sites in that area has to be the starting point. The planning practice guidance expressly says that for nationally or regionally important infrastructure, the area of search could be wider than the local planning authority boundary. So potentially you need to be looking at quite a large area for nationally or regionally important infrastructure. So potentially unhelpful for a developer's point of view, that sort of wide scope of search. But there is that's not the end of the picture, because if you can then show that your catchment area, because of some project specific need, is actually narrower, and the classic example of that would be grid connection. You might say it's only viable to go a certain number of 100 meters or kilometers or whatever from a grid connection. That will potentially define your search area and mean you don't have to start looking beyond local planning authority boundaries and draw that narrow. But that will require evidence, crucially, which needs to be in your application or produced during the examination. So that's the search area. Then the second of the 2 stages is, within your search area, what comprises a reasonably available alternative site? And this has been the subject of litigation recently. So the planning practice guidance, which the national policy statements defer to, say that reasonably available sites are those in a suitable location for the type of development with a reasonable prospect that the site is available to be developed at the point in time envisaged for the development. It goes on and provides some further detail on that. And that guidance is quite important in terms of how you approach, because if you take the view, well, I'm only looking for a site which is essentially identical to the site which I prefer to develop on, you may never find such a site, and that kind of rigid approach would potentially defeat the sequential test. But then if you go to the other extreme, again, it might be equally unacceptable. And that was what was explored in the case which was in the High Court earlier this year, called Mead Realisations against Secretary of State for Levelling Up. It's not an infrastructure scheme, it's a housing case. They've got permission to the Court of Appeal, so watch this space for that. But it's, again, a very full, thoughtful judgment from Ms. Justice Holgate. And of relevance to the infrastructure context, I think, he made the point that, in this quote there on the slide, that some development may be of a specialised or highly specific nature with particular or intrinsic requirements as to the site, form and scale of development, access and catchment. So that's the sort of consideration that you might rely on to say, for my infrastructure project, the alternative sites really do have to quite specifically match the site that I'm looking at, because they simply won't work for the development I'm promoting. And you compare that to the facts of the Mead case. So that was a housing case. And that is quite a scalable form of development in one sense. You can have a 50 home scheme, 100 home scheme, 150 home scheme, and therefore it's overly prescriptive, arguably, to say, well, I'm only going to look at other sites which can accommodate 156 homes, whatever my scheme is. Why not have three sites of 52 homes that also accommodate the same number of homes in total? That doesn't really work for a substation because they can't be disaggregated in that way. So it's quite fact specific, but those are it seems to me the types of issues that you might need to grapple with if you're trying to say, well, these sites really are not reasonably available alternative sites for my infrastructure project. Miss Justice Holgate, in his characteristically forthright manner, also emphasised the need for flexibility on all sides. So he disapproved of the claimant's overly prescriptive approach, but again, on the other side, wasn't willing to go too far either. So that's flood risk. I'm just going to deal slightly more briefly with some of the other issues arising. The first one is alternatives. And I deal with that deliberately next because there's a clear link with flood risk and alternatives, because the sequential test is essentially a policy which may force you to look at alternatives, as in alternative reasonably available sites. And there is obviously, alternatives are an issue more generally for infrastructure projects, a very well trodden one. And often, again, a focus for objectors, because of the inability for an objector to challenge the need for the project because national policy says you can't, or indeed even if you could, the need and benefits might be so compelling that it would be a hopeless task. So rather than saying the project's not needed, you try and say, well, it's needed but should be somewhere else. And there's loads of case law on this. Trust House Forte is probably the leading one, one of those classic judgments of Simon Brown, but there's a long list afterwards. And the Saces case in the High Court, this point didn't get to the Court of Appeal, but quite helpfully distilled the law on it. And in the first quote on the slide there, made clear that there is no principle of law that in any case where a proposed development would cause adverse effects, that these are held to be outweighed by its benefits. The existence of alternative sites inevitably becomes a mandatory material consideration. And it seems to me that is of some importance, because if you take Trust House Forte, as I say, the Simon Brown case, and on its face, and as some objectors might do, it might be read to say that there is a general requirement, particularly for large-scale infrastructure projects that cause harm, that inevitably you're going to need to look at alternatives, and you're legally required to do so. It seems to me that Saces in the High Court clarifies that that is not how Trust House Forte is to be read. The Save Stonehenge, the Justice Holgate case, the first Stonehenge challenge, made that quite clear as well, that essentially it caveats, I think, Trust House Forte quite heavily and takes a more nuanced approach. And simply because you've got that harm from a large-scale project being outweighed by benefits, that doesn't mean you need to be looking at alternatives. And rather, actually, the touchstone is exceptionality, which seems a much higher bar. And Mrs. Justice Lang said the case law does indicate that consideration of alternative sites will only be relevant to a planning application in exceptional circumstances. And I think that is as I say, a useful distillation of where we are on it. In terms of other points on alternatives, the 4 bullet points on this slide, I think, sum up some of the key considerations beyond that headline summary of the law. The first one, an obvious one, the EIA regs, obviously it's a requirement to consider reasonable alternatives in your ES. The second one, a more substantive requirement in the habitats regs, the possible requirement, if there's an adverse effect on integrity, to consider alternatives, to show there's no alternatives. The third one, policy in NPS EN1, a particularly important one which came into focus to the Quinn litigation, but has always been important. The policy in EN1 is clearly designed to avoid or to limit the vulnerability of NSIPs to this sort of alternatives line of attack. It's quite carefully structured and fully drafted policy and makes clear that you shouldn't refuse just because an alternative would cause less harm. And it also says that you can exclude, or the decision maker can exclude, vague and immature alternatives from consideration. That policy on alternatives has been tweaked recently in the latest MPSs. It used to say vague and incoherent. Now it says vague and immature, so fairly subtle change, but it at least shows, I think, that the drafters are paying attention to this alternatives policy, and it is, along with the sort of presumption in favour in the MPSs, policy on alternatives really is a linchpin of the MPSs and makes them work. And then finally on alternatives, a point made in SSESNZ that alternatives within the site are a bit different. It's an interesting nuance that it's one thing to say, well, a developer has to go and look at an alternative, you know, hundreds of kilometres down the road, and that may seem unnecessary, but the courts have suggested that the bar is lower for alternatives within the site if you can reconfigure your national grid substation, or you can move it within your red line. That may be something that decision makers should be more interested in and doesn't require that exceptionality threshold to be passed. So that's alternatives. Next, penultimate topic is generating capacity, which again of wider application, I think. So the generating capacity in this case, 2 offshore wind farms, one of them up to 800 megawatts, the other one up to 900 megawatts. The development consent order, just taking one of them, described the authorised work as a generating station with output of up to 100 megawatts. Oh, sorry, it's obscured by my screen. Yes, critically over 100 megawatts, comprising up to 67 wind turbine generators. So obviously the description of development different to the potential capacity of 800 or 900 megawatts. And this part of the challenge on the basis that, well, the examining authority and Secretary of State should have considered or potentially had to secure the total, some kind of maximum generating capacity sort of advertised by the promoter. And the court said no. And the reasoning is in this paragraph I put on the slide, that where the judge said, aside from the requirements of section 15.3 of the 2008 Act, there is no legal or policy requirement for the generating capacity to be formally secured. Furthermore, as a general principle, there is no legal requirement that all benefits which are given weight in the planning balance must be formally secured in order to be treated as material considerations. In this case, the decision to give weight in the planning balance to the generating capacity was a matter of judgment for the defendant. So that quite a pithy summary, I think, of the position that it is not essential for a benefit to be secured to be given weight. I mean, obviously, you may well want to secure a benefit to persuade the examining authority or decision maker to give it weight. It might be a very good thing, advisable thing to do, but there may be reasons not to. Project flexibility, an obvious one. So, you know, binding yourself to some capacity figure which may change because of technology changes may be imprudent. And likewise, some other benefits may be difficult or impossible to secure. Economic benefits, and I think that proves the point that just because you can't secure or guarantee an economic benefit, does that mean it should be given no weight? Well, obviously not. and the same must apply to generating capacity. And there's also the point, it seems to me, that harm and benefits may go hand in hand, and therefore the scale of harm may be proportionate to the benefit if the benefit doesn't realise, for instance, because the project isn't built out to its maximum scale or extent, then the harm may not be realised to that extent either, and so the planning balance may actually stay the same, just ratcheted down somewhat. So that is a point, I think, not always appreciated by those participating in examinations, that the relevance of securing benefits, whether it's essential to do so, and I think well borne in mind by those taking projects forward. So that's generating capacity. I'm not going to deal with the final topic because I think it's the least significant, and also I'm keen to leave a little bit of time at least for questions, but essentially it was cumulatives, dealing with the need to assess them, but restating the position, I think, from particularly the Pierce litigation from a couple of years ago. So that's what I wanted to cover. As I say, I think there is some time to field any questions from the floor or the online. So please fire away.
If we take questions from the floor, yeah. So it's Chairman ECLP. I was very interested in the talk on the non-objection clauses because it's quite a key thing for us. So the new Labour government is mooting a lot more CDO for housing, for example, and do be outside of the DCO regime. And I was interested in both views on what do you think the risk profile is of these non-objection clauses, where you haven't got a heavily inquisitorial process for a normal CDO. And developers might be good rather than leaving the objective scope to make a full objection and then doing a binding option agreement to not and say, you know what you're going to say, as you said it. What if they're good and they sort out to put these option agreements early on so that there are no real objections? You've got a process which isn't inquisitorial and these are now legally binding agreements.
I think the reality is it will be very fact specific. If you look at the two elements of the Court of Appeal's judgment, the first part is not fact sensitive. So if the developer owned all of the land, there wouldn't be any difficulty. That's not fact sensitive, but it is sensitive to the inquisitorial nature of the process to some extent. But if you think about it logically, the same would be true of the Town and Country Planning Act application. There'd be nothing intrinsically problematic, and it would be quite common for an applicant to own all of the land, or to have an option agreement over all of the land, and for the landowner not to object. So I think although to that extent the inquisitorial part of the rationale wouldn't apply, the underlying thinking, which is that the process is effective, notwithstanding that the owner may be the applicant, would still apply. I think the second element, you'd have to look at the nature of the issues in the particular case. So, for example, on the facts of this case, the claimants were trying to, unsuccessfully, to find some issue where realistically this could have made a difference. And they scrabbled around to say, well, what about this issue over here where there was an issue with a particular objector's land, but actually it turned out that that objector had pursued the objection, all the points had been raised and it had been dealt with and there was agreement. So that didn't stack up. The other one was about access to an area of riverside in order to make sure the ecological surveys were adequate. But when you went into it, that issue had been done to death in the examination. Everyone had tramped over the land, including, as it turned out, the claimants themselves. And so, again, it just didn't stack up. So I think you need to look at the particular issues. There'd be some cases where, frankly, it's unlikely that anyone could show that the second part of it, which is, well, has there been insufficient information to enable a properly informed decision?
has that arisen on the facts of this case? And that will be very fact specific. You can see some circumstances where it might be. Well, hopefully in most cases, if the developer is sensible and you make sure you've got proper EIA, matters of that sort, then it shouldn't arise.